Hello to our clients near and far. My name is Laura Musick. I am Labor and Employment Counsel with Green Herlocker in Richmond, Virginia. First and foremost, please know that we are thinking of our clients and friends of the firm during this trying time. Please know that we're here for you and we are happy to help in any way that you need. Don't hesitate to reach out to us. Second, to our clients and friends providing essential services, please know how much we appreciate your sacrifice. When so many are required to isolate and stay home, you're required to get out and keep things running, and we appreciate your sacrifice and your commitment. Finally, for our clients who have friends, family, coworkers, employers, employees, otherwise affected by COVID-19 all over the country, please know that we're here for you as well. If there's anything that we can do, please do not hesitate to reach out to any member of our team. Like so many of you, I'm working from home and monitoring the daily developments in labor and employment law and the state and federal orders being issued by governments all over the country. For this post, I want to provide you with some of the key takeaways from some of the most significant statutory developments, and one in particular, it's the Families First Coronavirus Response Act, also referred to as the FFCRA. This also includes the Emergency Paid Sick Leave Act, the Emergency Family and Medical Leave Expansion Act as well. It requires certain employers to provide their employees with paid sick leave or expanded family and medical leave for specific reasons related to COVID-19, and I'll go through a few of those. The Department of Labor's Wage and Hour Division is going to administer this law that goes into effect on April 1st, 2020. You might have heard April 2nd, but they walked it back to April 1st. And that will be in effect through December 31st, 2020. Generally, employers covered under the Act, and we'll talk about who's a covered employer later, but an employer covered under the Act must provide employees with up to 2 weeks, 80 hours, or a part-time employee's 2-week equivalent of sick leave based on the higher of their regular rate of pay or the applicable state or federal minimum wage paid at 100% for qualifying reasons 1 through 3 below, and I'll go through those, but generally those are state or federal government requires you to isolate you're diagnosed or told by a medical professional that you should quarantine related to COVID-19. This is all related to COVID-19. Or 3, if you're experiencing COVID-19 symptoms and you're seeking a medical diagnosis. So for one of those 3 reasons, you are eligible, an employee is eligible for 100% of their pay up to $511 daily or $5,110 total. An employee is eligible for 2/3 for qualifying reasons 4 and 6, which I'll explain are related to caring for an individual subject to either a self-quarantine or who has been advised by a healthcare provider to self-quarantine, again, related to COVID-19, or who is experiencing any other substantially similar condition specified by the Department of Health and Human Services. So that's number 6. And I'll go through those in a little more detail later. And then finally, the third option for pay is up to 12 weeks of paid sick leave and expanded family and medical leave paid at 2/3 for qualifying reason number 5, which is to care for a child whose school or place of care is closed, or if their child care provider is unavailable due to COVID-19 related reasons. And so those individuals are eligible for up to $200 daily and up to $12,000 total. A part-time employee is eligible for leave for the number of hours that the employee is normally scheduled to work over that period. Again, all of this is related to COVID-19, and I would caution you to not simply lump this in with FMLA. It is very different from FMLA. As you know, the FMLA employer has employer-related and geographic-related limitations. This new act is far more expansive, so it's very important because it does cast a much wider net if you fall within that 500 employee mark or below. So this is also available, leave under the act is also available for an employee who's been employed for at least 30 days prior to his or her leave request. That employee may receive up to an additional 10 weeks of partially paid expanded family and medical leave due to needing to care for a child or dependent whose school or place of care is closed, or like I said, whose child care provider is unavailable due to COVID-19 reasons. An employee is entitled to take leave related to COVID-19 if the employee is unable to work, including unable to telework. Very important, for 6 reasons. So these are, and I've kind of touched on these before, but I'll go through them by the number as the Department of Labor has laid them out. 1, if they're subject to a federal, state, or local quarantine or isolation order related to COVID-19. 2, has been advised by a healthcare provider to self-quarantine related to COVID-19. 3, is experiencing COVID-19 symptoms and is seeking a medical diagnosis. 4, is caring for an individual subject to an order described in 1 or 2 above. And 5, is caring for his or her child whose school or place of care is closed, as I've described before. Or 6, is experiencing any other substantially similar condition specified by the Department of Health and Human Services. So those are the general criterion by which employees and employers are to operate as far as knowing whether this applies to the particular employee. I have so many other additional questions that I could cover, but these are some of the ones that have come up more consistently over the past few weeks. And I plan on continuing to keep you all updated as this situation develops and as new laws or statutes or guidance comes out from the Department of Labor, especially with respect to this law. In the interim, please do not hesitate to reach out with additional questions. We're here for you and we are happy to help.